This subcommittee will play a vital role this Congress by ensuring that the committee is effectively able to obtain information relevant to our oversight obligations. Throughout the course of this Congress, the subcommittee will work to get answers directly from the departments and agencies that our committee oversees and hold their representatives to Congress accountable. We've seen time and again that the Biden administration's response to legitimate congressional oversight is to obstruct, delay, and obfuscate. Since the beginning of the Biden administration, committee Republicans have made at least 107 different requests for information and documents concerning the operations and actions of the Justice Department. Further, the committee has made at least 50 different requests for information and documents concerning the operations and actions of the FBI since the onset of this administration. Additionally, since the fall of 2021, the committee has requested information and documents concerning the operations and actions of the Department of Education. The committee has reiterated these requests for information and documents to all three of these agencies multiple times. On February 3rd, 2023, in the face of continued obstruction, Chairman Jordan issued subpoenas to Attorney General Garland, FBI Director Wray, and Education Secretary Cardona for documents. And while these agencies have begun to produce some documents, the committee continues to have concerns about the responsiveness of these documents. For example, the Department of Education's document production contains heavy redactions. The Department of Justice's document production also contains redactions. Additionally, on March 1st of 2023, the day the FBI was to comply in full with the subpoena, the Bureau produced just 4 pages of school board-related documents. Outside of their initial productions in response to the committee's subpoenas, the agencies have not substantially complied with other long-standing requests for information and documents. Now, we invited the FBI to testify at today's hearing, but the FBI refused. While we are disappointed that the agency is not here today to answer our questions, we look forward to seeing the FBI at the subcommittee's next hearing at the end of this month. We also look forward to engaging with both Mr. Uriarte and Ms. Graham today to discuss the production we have received to date and regarding the status of our other outstanding requests. Both officials are Senate confirmed and charged with the responsibilities of working with Congress. They lead large departments with substantial budgets and play a key role as a gatekeeper of witnesses and information. By being able to conduct expeditious and thorough oversight, the committee will be able to examine potential legislative changes that will help our nation as a whole. This subcommittee will work in a judicious and thoughtful manner to ensure that this committee obtains the information it needs in order to do its job. The chair now recognizes the ranking member, the gentleman from California, Mr. Swalwell, for his opening statement.
The chairman just referenced in the face of continued obstruction, and I think it's quite rich that we are talking about subpoena compliance under a chairman of the full committee who was absolutely out of subpoena compliance in the last Congress. So we're going to haul witnesses in here today and claim that they did not comply with subpoenas or requests. And that request is so rich because it's coming from a chairman who himself did not comply with the January 6 committee's request. So May 31, you see a letter sent to then Representative Jordan asking that he honor his subpoena. He was asked over and over and over, you were a witness to a crime. You were a witness to the greatest crime ever committed with the most criminals ever indicted in America. Will you help your country? Will you comply with that subpoena? No compliance, crickets, absolute defiance of the subpoena. And because of that defiance, the chairman was referred, and it's still pending, to the House Ethics Committee. And why? Well, it's because he took an oath. And I want to have the congressional oath put up there, but the congressional oath mandates that members of Congress defend the Constitution without any mental reservation, or as it says on the slide, purpose of evasion. Not responding to a congressional subpoena is a direct purpose of evasion. So this is our chairman, hauling all us here, everyone here today, people at the Department of Justice, the Department of Education who are doing important work to claim they are out of compliance when he himself is currently out of compliance. But I also want to go through what is being requested of the Department of Justice and the Department of Education, because they're actually in compliance. In fact, the first request that was sent to the Department of Justice followed, by the way, it didn't have a date on it as to when the compliance had to exist. Hundreds of documents were sent back. The request was so vague, it would be like typing in Google search, "What is Earth?" And the Department of Justice is saying, can you just be a little more specific and we will get you these documents? And they sent hundreds of documents back. And the claim here is that the Department of Justice has designated parents as domestic terrorists. You will see in the department's October 4, 2021 memo that they never used the phrase, from the Attorney General to anyone else in any of the documents produced, domestic terrorists, as a way to label parents. They are concerned, as local law enforcement is concerned, as state law enforcement is concerned, as federal law enforcement must be concerned, that threats are being carried out to local volunteers on school boards all over America. And apparently, the majority is here today to defend those who are making those threats. Taking time away from hanging out with the January 6th defendants at the DC jail, they're here today to defend threats like this. A threat that says, it is too bad that your mama is an ugly communist whore. If she doesn't quit or resign before the end of the year, we will kill her. But first, we will kill you. That was a threat sent to a child. These guys are defending that threat. They don't believe law enforcement has any business investigating that threat. I don't know what happened to the Republican Party that sided with law enforcement and law and order and public safety, but we're here today because they believe that threat is okay and no one in law enforcement should investigate it. Let's look at some of the other threats. We are coming after all of you. Traitors of America, a threat set to a school board member in Dublin, Ohio. This is why Hitler threw you C-word in a gas chamber. Anonymous threat sent to a school board member in Pennsylvania. These are the people you want to have this hearing for? You go and sympathize with the January 6th defendants. You're going to stand up for the people making these threats, and you're going to haul in people who are working hard for their country, and we're going to defend these people? Well, knock yourself out, because what you're going to find is they are doing nothing but protecting innocent volunteers across America who want to make sure our kids and the parent volunteers are safe in their school. But finally, I actually think when it comes to subpoena compliance, we should follow the Jim Jordan standard. Back in 2019, Jim Jordan and Elijah Cummings agreed a congressional subpoena is a powerful and coercive tool. It should be only used when attempts to reach an accommodation with the witness have reached an impasse, or when necessary to obtain certain sensitive information, such as financial information, or through a so-called friendly subpoena to protect a witness. This is the Jim Jordan standard, set back in 2019. Just like the subpoena he defied when the January 6th committee sent one to him, he's defying his own standard here today by not accepting what both departments are asking you to do, which is to be more specific in your requests, to meet with their staff and go through an accommodation process. So again, we can waste our time. You can stand with the January 6th terrorists. You can stand with the terrorists who made these threats. But if you're just a little more specific, I think you'll get everything you want from the witnesses we have here today. And I yield back.
I thank the gentleman. Without objection, all other opening statements will be included in the record. I want to welcome the members of the subcommittee, Mr. Moran from Texas, Ms. Lee from Florida. On my left, Mr. Ivey from Florida. No, I'm sorry, Maryland. Yes.
Although I like Florida.
I do too. But we are glad to have you all on the subcommittee. Before introducing today's witnesses, to respond briefly, what I did see after the oath of office that was displayed, I did not see the letter that the chairman of the full committee responded to his subpoena to the chairman of the January 6th Commission. It was quite a lengthy letter. Maybe it wouldn't have fit up on the screen, but it was quite detailed about engaging with the J6 Commission and those prepared to engage in a conversation about cooperation. He never received any further input from Chairman Thompson. So when the last effort at establishing that dialogue was made by the chairman of the full committee, and we were waiting a response from the chairman.
I would just seek a point of order. Are we responding to opening statements now? Because I'm happy to listen to yours and give a rebuttal, but I thought we had witnesses
briefly stating a fact, as is the prerogative of the chairman, and I'm happy to introduce the witnesses and move ahead with our questioning of them as well.
Would the gentleman yield for a moment?
I'm happy to
I mean,
allow for a conversation to occur, but I think it's going to occur. So let's go ahead with the witnesses' opening statements. Go ahead and get them sworn in.
I'll be very brief, and we can come back to it. But the comments that you just made are, I think, contradicted directly by the report that was issued that dealt with this issue specifically, as well as 3 other members of House Republicans who received subpoenas as well. So I can read through that later, but I did want to raise that now.
I appreciate that. All right, let's introduce today's witnesses. The Honorable Carlos Uriarte is the Assistant Attorney General for the Office of Legislative Affairs at the Department of Justice. In that role, he's responsible for managing the department's relationship with Congress. The Honorable Gwen Graham is the Assistant Secretary for Legislation and Congressional Affairs at the Department of Education. In that role, she acts as the liaison between the department and Congress. She also represented Florida's 2nd Congressional District here in the House during the 114th Congress. We welcome our witnesses and thank them for appearing today. We will begin by swearing you in. Would you please rise and raise your right hand? Do you swear or affirm under penalty of perjury that the testimony you're about to give is true and correct to the best of your knowledge, information, and belief, so help you God? The record will reflect that the witnesses have answered in the affirmative. Thank you. Please be seated. All right. Please know that your written testimony will be entered into the record in its entirety. Accordingly, we ask that you summarize your testimony in 5 minutes. The microphone in front of you has a clock and a series of lights. When the light turns yellow, you should begin to conclude. When the light turns red, your time has expired. Mr. Uriarte, you may begin.
Good afternoon, Chairman Klein, Rigmor Swalwell, and distinguished members of this subcommittee. Thank you for the opportunity to appear before you today and discuss the efforts of the Department of Justice and its components to respond to the information requests since the beginning of the 118th Congress. Not too long ago, I was sitting on the other side of this hearing room, serving as a staffer, first on the House Oversight Committee under the late Elijah Cummings, then on the Select Subcommittee on the Coronavirus Crisis under then-Chairman James Clyburn. My time as a congressional staffer showed me firsthand how transparency and accountability can improve the lives of everyday Americans. It also informed my belief that oversight can help the department better fulfill our mission to uphold the rule of law, to keep our country safe, and to protect civil rights. Shortly after the start of this Congress, on January 17th, Chairman Jordan initiated oversight by sending the department a letter with more than 80 separate requests for information. 3 days later, I responded, outlining how we can work together productively to get the committee the information it needs to meet its oversight responsibilities. I'd like to take this opportunity to reiterate a few of the points in that letter. First, the department and Congress have a long history of working together through the constitutionally mandated accommodation process. While this Congress is just 2 months old, we look forward to following that well-worn path with you over the next 2 years. Second, the constitutionally mandated accommodation process requires good faith efforts from both of us to accommodate each other's interests. Most of that effort takes place through staff-level discussion and negotiation. Third, The department is committed to responding to the committee's oversight inquiries to the fullest extent possible. As outlined in the 1982 Reagan Memorandum, we will do so while abiding by long-standing precedent which protects the integrity of our work. As I mentioned earlier, staff-level discussions are at the heart of the accommodation process. Historically, these have been working conversations where department staff meet with committee staff to better understand the committee's interests. On the committee's end, staff may explain broad requests and clarify whether certain materials are of interest and to be able to share how the committee expects to use the materials. And where, as here, there are many committee interests, we ask staff to help us prioritize. To be clear, prioritization doesn't just mean, what do you want first? It means, what are you really interested in learning, and how can I help you get the information you need? On our end, we try to identify the most efficient way to meet the committee's oversight needs, which includes identifying any department equities and crafting solutions to address both the committee's needs and those equities. As of today, a mere 2 months into the new Congress, the committee has sent 11 letters to the department and its components identifying 183 informational requests. These include at least 155 requests to search for and produce documents and 28 requests for transcript interviews. They implicate the records of potentially thousands of Department of Justice employees and will take significant resources and staff time to process. Given our unambiguous commitment to work with the committee to meet its oversight needs, we were surprised the committee deviated from longstanding practice and instead decided to issue subpoenas at this early stage. Nevertheless, as consistent with decades of practice, the department began responding to the committee's requests in good faith, making an initial production of documents last week that I think we can all agree is a good start. I am hopeful that sitting here today, I can learn more about the committee's interest to better inform how to leverage the department's resources to fulfill your informational needs. I want to reiterate my commitment to working with the committee in the tradition of accommodation and good faith negotiation as articulated by President Reagan in 1982. I look forward to a productive discussion today and throughout this Congress.
Thank you, Mr. Uriarte. Ms. Graham, you may begin.
Thank you. Good afternoon, Chairman Klein, Ranking Member Swalwell, and distinguished members of this subcommittee. Thank you for the opportunity to address the Department of Education's response to the committee's requests. As a former member of Congress, I can tell you the department recognizes the critical importance of congressional oversight to our functioning democracy. And we work every day with members and committees to provide Congress with accurate and timely information, irrespective of party or position. Accordingly, the department has been responsive to congressional inquiries regarding the topics of interest to the committee for more than a year. And we continue to voluntarily engage with the committee about its informational needs. On January 17th, 2023, Chairman Jordan sent a letter to the Department of Education about 3 topics. First, Chairman Jordan inquired about a letter a school board association sent to the president. Second, the letter asked about a Department of Justice memo. And third, the letter asked about an appointment to the independent, nonpartisan National Assessment Governing Board. Immediately, the department began to voluntarily engage in the standard accommodations and compromise process with the committee, resulting in our February 2nd response expressing our readiness to work with the committee regarding its oversight requests. The department's response also noted that an independent investigation commissioned by the School Board Association had already addressed these issues in May of 2022, more than 9 months ago. However, despite our February 2nd response, the chairman served a subpoena to the department for documents the next day. On February 13th, department staff communicated that a document production would be forthcoming by the date specified in the subpoena and reiterated our commitment to continue to engage with the committee on the matter. However, on February 16th, 2023, nearly 2 weeks before the committee's requested production date, I received notice that I would be called to testify about the department's response. As promised, on March 1st, prior to the committee's requested production time, the department transmitted more than 1,000 pages of responsive material to the committee, and we continue to engage with the committee about its informational needs. The Department of Education has a critical mission to promote student achievement and preparation for global competitiveness by fostering educational excellence and ensuring equal access. As part of that mission, we believe that parents play a critical role in their children's education and that education leaders at all levels provide opportunity for parents to be heard. Our significant and timely production of responsive documents and ongoing engagement with the committee demonstrate the department's continued commitment to working with Congress in good faith while ensuring that we fulfill our core mission of fostering educational excellence for all of our students across this great country. I look forward to your questions about this process, and thank you.
Thank you, Ms. Graham. We will now proceed under the 5-minute rule with questions. I anticipate we will have 2 rounds of questions today, and I will recognize myself for 5 minutes. Mr. Uriarte, how many staff members do you have at DOJ's Office of Legislative Affairs?
Congressman, thank you for the question. The Office of Legislative Affairs at DOJ is actually a relatively small component. We have a total of 25 full-time staff positions. I believe we have 21 total full-time people currently in our office, in addition to some detailees.
How many are dedicated specifically to responding to subpoenas from Congress?
Thank you for the question, Congressman. The way that we have structured the team is to have a number of different attorneys who can do multiple different things at the same time. So depending on what the matter is and how it comes into the department, et cetera, we may staff it differently. So it really just depends on the matter.
No one has their job description solely as responding to subpoenas?
No, that's correct, Congressman.
How many members of your staff are working remotely?
I don't know the answer to that question, but we have implemented some flexibility in our work arrangements with our staff to accommodate various requests, and frankly, we found it to be quite productive.
Would you say that that would be deterring any production of our requests?
Absolutely not.
Okay. Who makes the final decision about what requests to respond to and how much information to provide?
I appreciate the question, Congressman. What I can tell you is that at the department, we are always going to be guided by finding the most efficient and effective way to get you the information you need. That means that we'll work with the impacted components. We will work with them to identify what materials are at issue, how we can get you the information, et cetera. And then we will try to get that information over to you. There's no specific one person who is making that decision. It is a number of different equities within the department that come together to provide Congress with the information they're looking for. And again, what will guide us there is to finding the most efficient and effective way to get you the information that you're looking for.
Okay. So your first go-to when deciding about what requests to respond to is not Paul Coburn?
Congressman, actually, the first go-to that I would start with in determining what to respond to would be to work with your staff, frankly. You know, I think that conversations that happen between our staff and your team are the most productive and can really help guide us to what is the priorities of the committee, what are the key informational interests of the committee, and it really helps us to do our job of being efficient as possible.
Okay. Let's talk about your budget. Can you estimate your budget for FY23?
So the Office of Legislative Affairs falls within the GA bucket. I think that's the general administration bucket. We don't have a specific line item in the budget. I know the spend plan is still pending before the Appropriations Committee, so I don't have that precise number on me, but I'm happy to follow up with your team on that.
And how much of your budget would you say, since you can't articulate what your budget is, how much do you think you spend on responding to these requests?
I think it would be hard to put a number on that. What I can say is that it is something that takes up a significant amount of staff time within the Office of Legislative Affairs. And that's because it is a priority for us. As the Attorney General has articulated previously, being responsive to Congress is significant to him. It is a significant priority to him. And to me personally, as a former congressional staffer, I think this is really something that we ought to be prioritizing. And so it's harder to talk about it in terms of dollars and cents, but what I can certainly speak to is the amount of staff time that we dedicate to
Well,
this process.
quantify that then. Quantify that staff time for me. Half? Quarter?
It really depends on the moment in time you're talking about, but it is a significant investment of time by the staff in our office.
Okay. How many are on staff at the FBI to respond to these requests, and how much of their budget is dedicated to responding?
It's a good question, sir. I can tell you they have about 30 full-time staff members in their Office of Congressional Affairs. They work with others at the FBI, obviously, to respond to your requests, and I know they share my commitment to being responsive to your requests.
Can you speak to the specific dollar figure for their budget?
I cannot, but I'm happy to get back to you.
Okay. We definitely expect you to speak for the FBI, because that's what we were assured of today. Was we were told, oh, the FBI doesn't need to be there because DOJ can speak for them. So if you don't have those numbers for us right now, I'm disappointed, but I would appreciate you getting them for me. What was the policy of the DOJ in responding to requests from the minority last year? Did you respond?
Congressman, last year we did send a number of responses to the committee. I believe in response to 48 letters from Ranking Member Jordan, we sent 34 letters in response.
What about documents?
I don't have that number in front of me, but I can tell you that certainly in this Congress, we are committed to producing documents and information in response to the chairman's letters, and we're going to continue to do so, just as we did in the first production to the committee a couple weeks ago.
Thank you. The gentleman from California is recognized.
Thank you. And I want to thank both of our witnesses. Congratulations. You have done something that Chairman Jordan was not willing to do. You were invited to come and talk to Congress about information you had, and you showed up, and now you're being asked questions and you're answering them. It doesn't seem so hard because you took an oath to follow the law. And so we're grateful that you're here and doing something that the chairman was unwilling and is unwilling to do. Mr. Uriarte, I want to ask you, though, I read the Jim Jordan Standard to you, which was a pact that he and Elijah Cummings made in 2019. A congressional subpoena is a powerful and coercive tool. It should be used only when attempts to reach an accommodation with the witness have reached an impasse, or when necessary to obtain certain sensitive information, such as financial information, or through a so-called friendly subpoena to protect a witness. So, Mr. Uriarte, thus far, has Chairman Jordan followed his own Jim Jordan standard in his request to you and your department?
Congressman, thank you for the question. I think what you're talking about here is generally the constitutionally mandated accommodation process. And I talked about in my opening, my experience over many years of doing this work is that that is a back and forth between the committee and the department, where we understand from the committee what their needs are. We work through voluntary production of documents, et cetera. And that, yes, when there is impasse from time to time, there will be a subpoena that may be issued by Congress. But what I find is that the most productive conversations we can have are those about voluntary production of documents and information, and especially given where we are in this Congress, it certainly, there was no reason to send a subpoena. We were ready to voluntarily comply with the committee's requests.
So speaking of voluntary compliance, you received your first request for documents on January 20, is that right?
January 17th, I believe, was the first request in this Congress.
And how many days did it take you to respond to that request?
We sent a letter back on the 20th, 3 days later.
So 3 days. And in that letter, did you offer to meet with the chairman's staff to discuss the request?
We did.
Did they take you up on that offer?
They did not.
Have you ever heard the phrase, won't take yes for an answer?
I have, sir.
Does that sound apt here?
Certainly, I can tell you that we are looking forward to continuing to dialogue with the committee staff and certainly hope that we can do so in the spirit of accommodation that I mentioned earlier. We do have a good relationship with the committee staff, and we appreciate that, but we certainly hope that we can continue to bolster those conversations by additional dialogue about the committee's interests and what the department can do to meet those interests on a voluntary basis.
So after Chairman Jordan wouldn't take yes for an answer, he followed up with a subpoena with 9 requests for 94 field offices asking for documents from 118,000 employees. Is that right?
That is correct.
How much time did it take you to prepare for this hearing, you and your staff?
I took dozens of hours.
What would you have been doing otherwise?
We would have been working on the committee's requests and producing documents to the committee.
If you weren't doing that, though, what other Department of Justice public safety priorities could you have been working on?
Well, certainly the Office of Legislative Affairs works on a number of different issues, including helping Congress with legislation, providing them information about grant-making activities of the department, about what's going on in their districts. But more broadly, across the department, when we do receive a request like this, it will impact the law enforcement components and prosecutorial components of the department. In this instance, there was a significant volume of materials that we had to collect from the Executive Office of United States Attorneys, and certainly that does take away from their time to support the United States Attorneys in their mission to protect the United States.
And Mr. Uriarte, at your Senate confirmation vote, how many Republican senators voted against you?
On the floor vote, it was a unanimous vote in my favor.
And Ms. Graham, our dear missed colleague, in your confirmation vote, how many Republican senators voted against you?
That would be helpful. Thank you, Ranking Member Swalwell. My vote on the floor was a unanimous as well.
Great, thank you. So you're looking at 2 bipartisan, unanimously confirmed witnesses who, again, did something that the chairman of this committee was not willing to do, which was follow a subpoena request. And I yield back.
Gentleman from New Jersey, Mr. Van Drew, is recognized for 5 minutes.
Thank you, Chairman, and thank you both for being here today. Just something I want to correct in I guess the way we speak and the vocabulary we use. When Mr. Swalwell, Ranking Member Swalwell, says it won't take yes for an answer, a yes answer is giving the documents. A yes answer is not saying, well, we'll meet, we'll talk, we'll use some slick language, no offense, but you're not actually getting the documents. A yes is a yes, a no is a no, and there's a lot of space in between, but that was no yes answer by anybody's imagination. And you also wonder why it came to the point that, Chairman Jordan was asking for all these documents, because quite frankly, we don't know the answers. We want to know what's really going on. This isn't really complicated. The American people want to know what's going on. I want to know what's going on. This committee wants to know what's going on, and saying that we'll work with you and we'll talk about some things and, it'll take some time, but we're not sure. That doesn't tell us what's going on. So let me just be very candid about that. And, let me talk about this a little bit, though, too. On August 8th, 2022, and I'm sure you all remember the date, federal agents executed an unprecedented, and it was unprecedented, raid on the residence of the former President Donald Trump. Since then, we've seen several current instances of classified documents belonging to our current president, President Biden. And they've been acquired from a number of locations, from Boston to D.C., yet no raids. No heavy media presence, no large team of federal agents digging through all his personal effects, going through his wife's clothing and into her closet and her drawers. None of that. We still have no idea who had access to these classified documents, which is a grave concern considering reports on anonymous donations to China being made to the Penn Biden Center, where some of these documents were found. It's weird. I don't care what anybody says. It doesn't make sense. How is it that the FBI can treat President Trump as a criminal when sending raids of dozens of federal agents there, yet with President Biden, for what would seemingly be a similar issue, there is no sense of urgency? And remember, he had his own secret police there. They had their own people there. Were literally, were we afraid of them? Did we think President Trump was going to come out with an Uzi? I don't know why such a show had to be made of it, but it sure was. This is unfair treatment. It's unfair treatment between two citizens, one Republican and one Democrat. You know, as Republicans, we get used to it, but it doesn't mean we like it, and we don't. American people have begun to question trust in federal law enforcement. They have. Don't believe me. Look at every poll that has come out recently. Not the folks working, actually doing the job, but the people at the top, the people who are in administration. American people right now, if you were to ask the average Joe or Jane, they say, man, I don't know. I don't know what to think. I don't know to trust them. If the FBI can go after a former president of the United States, unprecedented as they did, who is to say they couldn't do this to any American? Well, I guess the answer is they could. Attorney General Merrick Garland went after parents and a former president of the United States, yet he failed to investigate individual firebombing of pro-life centers. I guess he doesn't like pro-life centers, but that isn't his job. There were fire bombings there, and we really needed to investigate, and we really needed to protect. He failed to go after BLM. He failed to go after Antifa and the riots in 2020. Is it a coincidence? Is it a coincidence? I think it's intentional. The House Judiciary Committee plays a role in the oversight of ensuring that this current administration is not trampling on the constitutional rights of our American citizens and strongly enforcing the laws on those they see fit. That's why Chairman Jordan is sending subpoenas. He can't get the information. None of us can. Excuse my voice, been doing a lot of talking. So I have questions, and I know I only have a little bit of time, but I'll try to get through the first one. These letters requesting documents and communications relating to the execution of the search were sent in August of 2022, and again in January of this year. So it's not like we only had a day, a week, a month, a year. When will the DOJ, and I want a specific answer, when will the DOJ be providing these documents to this committee?
Congressman, thank you for the question. As I said earlier, you know what guides us in responding to
And
oversight
forgive me
requests.
for 1 second. You don't have to say thank you for the question every time because I know you don't like a lot of these questions, so you can go right into the answer, at least with me. Go ahead, thank you.
I appreciate that, Congressman. So, as I said earlier, we are committed to working with the committee to help get them the information they need. But certainly in this instance, as we've referenced previously in letters to the committee, the matter that you're talking about is an ongoing matter. There are a number of ongoing matters at issue there, and protecting the integrity of those investigations is something that is incredibly important to the Department of Justice. Now, we have a long history of working with Congress in those instances to answer their questions, to provide their information, even when there are those ongoing investigations, but we must find a way to do so that protects the integrity of that work. So happy to engage with you and the team, the staff, to find a way to meet that informational need, but there are significant equities at issue in those matters.
I'm going to yield back in a second, but Mr. Uardi, I'm sorry I don't agree with you. We can answer these questions, and we can answer them in a timely way. This is not timely, it's not appropriate, and that's why we're at wit's end. I yield back.
All right, the gentleman's time has expired. The gentleman from Maryland, Mr. Ivey.
Let me say that this has been timely, actually. So the gentleman from New Jersey and the chairman have made a number of comments. I want to try and deal with them in categories. I would need more than 5 minutes to correct all the misstatements that were made. But just broadly speaking, on the one hand, we've got parties who have shown how to comply with subpoenas, and they're the ones testifying in front of us today. Department of Education's done a rolling production, 1,000 pages. Department of Justice just under 500. The term rolling production is standard in not only congressional investigations, but in the federal courts. And the type of conduct that was done by the Department of Justice, which is to reach out to the people who sent the subpoena and try and engage in a conversation. What are you looking for? How do we want to try and have a discussion about how to comply. Not only is that standard practice in federal courts and in Congress, by the way, at least I was in the Whitewater hearing, so going back, what is that, 25, 30 years, We were doing it then, and I know there's a memo in the Department of Justice about the accommodation provision that dates back to 2000. And in federal court, if the parties had to refuse to respond like the Republicans did for civil or criminal discovery or subpoena responses, a judge might impose sanctions, including attorney's fees. I would say that your conduct's been great, the Republican committee staff, not so great. And then with respect to my colleague from New Jersey's comments about Donald Trump and the chairman's response about Mr. Jordan, I think that's why they're on the opposite side of our two witnesses here today, because they refuse to comply. Donald Trump, even worse than just refusing to comply, pretended to comply and actually made false statements about complying. That's under investigation now. We'll let that go forward with the Department of Justice. But as is standard practice with the Department of Justice, if you lie about producing documents, they go get them. They don't sit there and let you lie and just move on. They go get the documents, and that's exactly what they did there. And you know that's not surprising or, targeting Republicans because they treated Pence the same way they treated Biden. You got voluntary compliance by the Biden and Pence. They didn't go into their houses because they were providing the documents. And I think that's the same issue that arises with respect to the points Congressman Swalwell was making about Chairman Jordan. There were others as well who refused to comply. The Speaker is another one, Congressman Perry. Multiple people received subpoenas from the January 6th committee, refused to comply with them, made no attempts to figure out how to comply. In fact, Chairman Jordan sent a letter back. Not only was he not going to comply, but he said he wants all the materials referencing him in the select committee's possession and all internal legal analysis related to the constitutionality of member subpoenas. Now imagine if every time this committee sent out a subpoena, they got an answer back from the target demanding information about the investigation that they're conducting. I guess you could have done that as the Department of Justice, but instead of doing that in Department of Education, you complied. You turned over documents to the best you could discern what they were asking for, and you did it in a timely manner. You said it was a rolling production. I think what'd you get it, like 30, 45 days ago, something like that? So I would think under most circumstances, it looks like a reasonable effort to comply and actual compliance actually as well. So I actually commend you for what you've done there. And I join Congressman Swalwell in raising concerns about those who haven't complied with producing subpoenas, getting up on the high horse and complaining about people who are actually complying with the subpoenas that they're issuing now. I've got a couple other things I want to raise and that go to the direct issue with respect to the subject matter of the subpoenas. I'm running out of time, but I'll come back and deal with that on the next round. But I do want to say this too. The chairman raised heavy redactions as a concern. That's another point where I would think there'd be conversations between the majority staff and the Department of Justice. What did you redact? Why did you do it? And they can make a decision about it, but they have to respond to your answers and your information in order for that dialogue to move forward. And the comment about longstanding requests that the chairman made, I think ignores the fact that the new Congress just started a few weeks ago. So again, I commend you on the work that you've done in trying to comply with these requests. I apologize to you for being in the crosshairs of an obviously politicized effort to attack the Biden administration and to try and score political points when we've got real work we could be doing on behalf of the American people. I yield back.
I thank the gentleman. I think it's important to clarify that the chairman of the full committee never indicated that he would not comply and that he responded.
But did he comply?
And that he responded and that he was awaiting further statements from Chairman Thompson.
Still waiting.
As I recall, the subpoena for the president was withdrawn.
Would the gentleman yield?
The gentleman from Texas is recognized, Mr. Moran.
Thank you.
Point of order. If the chairman's going to make comments out of order, you should at least give us a chance to respond to them.
Thank you, Mr. Chairman. Secretary Graham, my questions are going to be for you. Thank you for your attendance here today. I want to focus my questions on process, specific topics. You received the request, the subpoena for the 2 sets of documents through the subpoena on February the 2nd. About 1,000 pages were produced. Were you in charge of the responsive effort in that regard?
Congressman, thank you very much for the question. Part of a team that worked very hard from the moment we received this request to respond, and the 1,000+ pages that we responded with are reflective of the hard work that went into getting it to you all.
You noted in your letter that there's going to be some supplemental requests, I believe, or supplemental documents produced. Where are you at in that process? When should we expect those documents to be produced?
Thank you for the question. Actually, our teams have a meeting scheduled for Tuesday, and look forward to that being part of the conversation, the ongoing conversation that we're having.
You don't have any timeline for us at all, 30 days, 14 days, that you can give us when another batch of documents will come through?
That's part of the process that will be continuing on Tuesday, I believe, and hopefully we'll be able to come back with those timelines through the process of our teams discussing.
I noticed in this batch of documents that were produced, there was no assertion of privilege or no assertion of objections to the requests. Have you asserted any objections or withheld any documents as a result of any objections or assertions of privilege?
No, sir.
Do you anticipate that that will be the case based on the 2 requests made under the subpoena to the Department of Education?
What I would appreciate is if we could take that question back. I don't anticipate it, but certainly would like to have an opportunity to have a conversation about it. But no, sir, I do not.
In a number of those documents, there was heavy redaction, so I want to talk to you about the redaction process and what you do to determine exactly what you're going to redact and what you don't. I presume at the end of the day, you're the one that makes the final determination about what gets redacted. Is that accurate?
The redactions are a result of either let me see if I can get the word out correctly, deliberative process, or attorney-client information or personal information, which is protected because of those reasons.
Other than the deliberative privilege, is there any other reason why you would have redacted or the agency would have redacted, the department would have redacted anything from these documents?
Attorney-client privilege and also personal information that we want to protect from public.
I want to show you a couple of these documents back here that you see behind me. You'll notice that probably about 99% of those documents have actually been redacted. Do you recall actually looking at these documents and approving the redaction on these documents?
Mr. Congressman, in terms of the production of the documents, that's a conversation that I hope can be part of the accommodations process that's ongoing. And good news is the opportunity is going to come up next week on Tuesday.
When you go through the process of gathering the documents, these were very specific requests. They weren't overly broad requests. They were very narrowly tailored. How do you go through the process of determining within the department what documents would or would not be responsive?
It's a technical process, and happy to take that question back and provide a response.
Do you guys do an email search with query words that you use for emails or documents within the electronic system?
As I understand the process, yes, that's what is conducted, but again, happy to take that question back to the teams that are working on it and provide a response.
Who determines what words or phrases are included in that?
Again, that's a technical question. I prefer to have the teams discuss it in the next meeting on Tuesday.
I'd presume that at some point, though, you review those words and determine whether or not it's actually going to meet with the request, or somebody from your team is going to do that.
I want to be very accurate in providing you that information, Congressman. So again, certainly look forward to having that conversation and getting you the information you seek.
I understand that there's been some requests for the production of some employees to appear and give testimony or to speak with the staff. Do you guys intend to produce those individuals?
We have been engaged with the committee on this topic for over a year and continue to do so. And those conversations are taking place through the accommodations process.
One of the things that Mr. Uriarte mentioned earlier was this idea of good faith efforts. And I'm genuinely concerned. I'm new to Congress. I have practiced law for 20 years, and I was a judge for 6 years. And I'll tell you, as I look at the redaction here, it concerns me about whether or not good faith is being exercised by the Department of Education in its production. Can you commit to me that good faith is actually being done to ensure that there's transparency in the production of these documents?
Congressman, let me assure you, and welcome to Congress, that the incredible team at the Department of Education, of which I am so proud to be a member of, has worked very hard to make sure that we produce the documents as requested under the subpoena, and we will continue to do so, Congressman.
You mentioned about this team that you've put together to respond to these documents. How many people are on this team?
Congressman, it's a cross-agency effort. If you want the specific number, happy to get you that number.
Can you give me an approximate number?
Congressman, I'm here to talk about what we did produce, but happy to answer any questions you have, and we'll certainly get back to you.
All right.
Gentleman's time is expired.
I just want to understand the process, because really this is a process set of questions and ongoing for me to be able to understand why you're producing things and why not. I need to understand what's going on behind the scenes. So when you leave here and go back and talk to folks, besides your attorneys, who else are you talking to say, what have we produced? What else is left to produce? How can we get this gathered and get this to the committee?
That was a rhetorical question. No. Gentlelady's recognized to answer.
Congressman, it is my responsibility, and I take it very seriously, to get the answers that you're seeking, and look forward to taking that question back and providing you a response.
I apologize, Mr. Chairman. I went way over time. Sorry about
No,
that.
that's all right. We've got a second round, so save some for the second round. Gentlelady from Florida, Ms. Lee.
Thank you, Mr. Chairman. Following the May 2022 unprecedented leak of the draft Dobbs opinion, the justices of our Supreme Court have been subjected to harassment and intimidation campaigns, not only in the vicinity of the Supreme Court, but in public and also at their private homes where they reside with their families. This unlawful and insidious conduct culminated in June 2022 when a man attempted to assassinate Justice Brett Kavanaugh at his Maryland home. To be clear, when the intent is to interfere or impede the administration of justice or to influence or intimidate a judge, this is not protected First Amendment conduct. This is a crime. To date, the efforts by the Department of Justice and the FBI to prosecute and convict the individuals responsible for this criminal effort at intimidation outside the private residences of justices and their families is wholly inadequate. As a former judge, I will tell you this failure is an affront to every single man and woman across the United States who is serving in the judiciary. At the same time, the Federal Bureau of Investigation saw fit to begin investigating what it deems radical traditionalist Catholics as an extremist group. Taken together, we have a Department of Justice that has failed to prosecute violent extremists threatening the lives and safety of our Supreme Court justices and their families, but has instead devoted resources to investigating Catholics and their religious traditions. Congress must engage in oversight to ensure that Americans are not being targeted for investigation and surveillance by our government for practicing their religious beliefs, and that our judges and our justices are not being left vulnerable and in danger due to a failure to enforce the law. It is imperative that the Department of Justice and the FBI promptly and completely respond to our requests so that we may ensure the rights and freedoms of Americans are protected and there is complete transparency to the American people. With that, Mr. Uriarte, I would like to direct my first questions to you, and specifically related to the Federal Bureau of Investigation. A February 16th, 2023 letter to Director Wray On January 23, 2023, the FBI's Richmond Field Office published an official document that linked racially or ethnically motivated violent extremists with a radical traditionalist Catholic ideology. We made a request to allow this committee to assess the extent to which the FBI has misused its federal law enforcement resources to target Catholic Americans for their religious beliefs. That document requested all documents and communications referring to intelligence products about this subject for a period January 20th, 2021 to the present. Can you tell me, sir, how many documents have been provided to this committee that are responsive to that request?
Congressman, thank you for the question. I want to start by just making very clear, as the Attorney General said last week, and I know the Director has spoken to this as well, that product did not meet our standards at all. It was offensive to me personally, and as the Attorney General said last week, it was offensive to him. What I can tell you is that the FBI took steps immediately to withdraw that memorandum and are doing aggressive analysis to understand how that even came to be. And part of that will be, of course, responding to this committee, which we expect we will do in the coming weeks. That is a really important issue. I completely agree, and I expect that we will have good faith back and forth on that topic so we can get the committee the information it's looking for.
To this point, have any documents been produced that are responsive to this request?
My understanding is that there have not at this point been any documents produced, but that we have responses to those requests in the queue, and we hope to get them to you shortly.
Do you have a timeline or an approximation about when you will be able to get us the documents that are responsive to this request?
Congressman, I appreciate your interest in this issue. As I said, it's something that is important to me as well. I know that we have something that is forthcoming soon. Just, I don't want to overpromise and underdeliver, so we will get back to you shortly on that.
I certainly appreciate your acknowledgement that this is a serious issue and your acknowledgement that there is an intention to comply in the future with this document request. However, would just note that our efforts here, that our endeavor here is to ensure that we are actually receiving and reviewing these documents so that we can provide transparency to the American people about the contents therein. So with that, Mr. Chairman, I'll yield back.
I thank the gentlelady. All right, we're going to start the second round. Yield 5 minutes to myself for questions. Mr. Uriarte, I'm looking at a list, and I want to go back to the question I asked during my last round. Your policy, or the policy of the department, regarding responsiveness to Republican requests or Ranking Member Jordan's requests when the Republicans were in the minority. Is it your statement today that you provided documents to Ranking Member Jordan in the 117th Congress?
Congressman, what I was saying earlier, just to clarify, was that my understanding is that in the last Congress, we provided 34 letters to then Ranking Member Jordan in response to his various requests.
Okay. My understanding that just regarding the school board issue, over 100 letters were sent to DOJ components over the course of the 117th. Does that reflect your recollection of the situation?
I don't have that number in front of me, but I'm happy to take that back.
Okay. Beginning back as early as October 13th of 2021, when a letter was written to Attorney General Garland. There have been letters to U.S. attorneys requesting documents dated November 1st, 2021, to FBI Director Wray, November 3rd, 2021, requesting documents on the FBI's role by November 17th, to Attorney General Garland on the completeness of testimony regarding the whistleblower disclosure on November 16th, 2021. I can go on, but you essentially see that over the course of 2021 and 2022, they weren't just requests for a letter, they were requests for documents. And they were responded to with generally a single sheet letter saying, we will not comply, essentially. So now that we are in the majority, these same requests were given to you on January 17th. First, actually, after November's election, November 18th, Attorney General Garland was given a letter stating Republicans will pursue the matter into the 118th and requesting not only testimony but responsiveness to previous requests. And then January 17th, another letter reiterating not only past requests but outstanding requests in the new Congress. So when we say these requests just came in, we've just gotten these requests this year, I think it's important to provide some context about the timeline over which Republicans have been asking for information, asking for documents, and receiving very little. And your testimony is that while you responded with letters, were any documents provided before Republicans took the majority?
Not to my knowledge. What we were endeavoring to do is to, again, begin the process of informing the committee about the answers to their questions, was to do so through a narrative format. That's oftentimes the first step that is taken here. And yes, we of course are happy to, whether as a ranking member or now as chair, engage in the accommodation process. But of course, everything has started anew with the new Congress, and we've endeavored through these processes and through the letters that we've sent to have that voluntary discussion about your priorities.
Were you accommodating the majority at the time during the 117th Congress, providing them with document production?
I don't have that number in front of me, but I can tell you that whether it has been the majority or the minority, we work through various requests.
That wasn't my question. Did you ever provide documents to the Democrats when they were in the majority in the 117th?
I'm confident that we provided documents to this committee in the last Congress in response to requests from then Chairman Nadler, and consistent with the constitutional role the chairman of the committee plays, and as they speak for Congress, the department has taken the position that there is an additional authorities that are granted to the chairman. And of course, that does inform our responses to the committees.
Then
but
I will
regardless of the role of the individual member, we do endeavor to be responsive to all members and to treat them as constitutional officers, which we recognize.
I'm pleased at that last statement, that respecting that the majority should receive some response and some action on the part of the department, so that now that there is a different majority, your responsiveness to the majority now should be similar to your responsiveness to the majority then. And it's disappointing to hear that there was essentially a double standard where the majority was getting those documents and the minority was getting nothing during the last Congress. But you knew about them, and that's the important thing. You've known what we were asking for, so it shouldn't come as a surprise, and we should be seeing results by this point. The gentleman from California is recognized for 5 minutes.
Well, now we know why we're here. After a round of questioning, it's clear why we're here. We haven't heard one shred of evidence that any parents were unlawfully targeted by the Department of Justice, but we did hear a lot about Mar-a-Lago. And that's why we're here. Because when the Republicans went into the majority, they formed the largest law firm in Washington, D.C., who would advocate on behalf of just one client, one very, very small man with a lot of grievances that they're going to carry out. We're living through today a corrupt bargain that'll have installment payments week after week to fight the grievances for that one small man, to harbor an international wanted criminal, to put a January 6th sympathizer on the Homeland Security Committee, to defund the troops by $75 billion, to make sure that that honest brokering journalist Tucker Carlson gets his hands, and only his hands, on the January 6th footage. And, as we just saw today, to attack the cops who protect our kids and volunteers at our schools. Again, we didn't hear any evidence of any parents being unlawfully targeted. We also didn't hear any condemnation of the 3 threats, of many threats that were put up there. I will condemn the violence that the gentlelady from Florida referenced. I'll condemn violence by Antifa, any threats made toward any judge, whether it's Judge Kavanaugh or any other judge. I'll condemn the violence that took place in Portland. My colleagues and I do that over and over, but there hasn't been one condemnation of the threats that were made to parents. And so if you don't condemn it, then you're condoning it. And if you're condoning it, it's going to fester, and more threats are going to be made to parents. And what they're asking is that you don't investigate that at all. That because these parents share their political beliefs that are making these threats, you shouldn't investigate them. That's what's being asked of you at this hearing today. I do want to ask, though, with regard to the redactions on those documents, Ms. Graham alluded to it, but am I right that anyone who is below what's called an SES level in federal government, which is a senior government employee, any employee's information, their name, contact information, et cetera, would be redacted just to protect those civil servant employees?
Yes, personal information is redacted.
And I want to ask, Mr. Uriarte, you've referenced over and over that you're willing to meet with the staff. You're here, you've got your team here behind you. Ms. Graham's here, she's got her team behind you. I see the staff of the majority is here. Are you still willing to sit down with them and meet with them to be a little more specific? And when I say be more specific, in the definition section of what they sent over to you, the term document has about 20 lines that define document. And they're asking for documents of 118,000 employees. So are you willing to still work with them so that they can be more specific and then you can be more responsive and in a manner that suits the needs that they have? Mr. Uriarte?
Absolutely, we would welcome that.
Great.
Yes.
Ms. Graham?
Absolutely, and look forward to having that opportunity on Tuesday.
Great. Thank you. I yield back.
Gentleman from New Jersey is recognized for 5 minutes.
Thank you. Well, first of all, and please don't take this the wrong way, but that was wonderful theatrics, but let's really talk about fact. The fact is that we do have information that relates to parents being harassed and parents having problems because of their beliefs and because of wanting to be involved in their child's educational process. I have that information here, Chairman. I ask that it be entered into the record so my colleagues can all see it.
Without objection.
Thank you. And it makes some interesting reading. Parents should never, ever have to go through that. The relationship between a parent and a child is extremely important, and I think the parent always has the ultimate say. Secondly, there was some discussion that the Republicans won't take yes for an answer. And I want to correct that. No, the deal is we're not going to take no for an answer. We're going to go over this over and over and over and over again, no matter how long it takes to get the information, because I know no more now than I did when we started this meeting. And anybody that's honest and candid knows no more now than when they started the meeting. The amount of time it has taken to try to get information. The reason for the subpoena is because we can't get accurate information. The fact that, and yes, the Trump issue is an issue, because why is it that in one case you have dozens and dozens of individual law enforcement, FBI, and others coming down, and in the other case, you don't? That's just not fair and not necessary. Again, nobody, whatever you think of Donald Trump, you don't think he's going to be coming running out with a squad of his own Secret Service and Uzis and God knows what else. There was no need to do that. They were having a conversation. Again, it was theatrics. You know what American people are tired of? They are tired of theatrics. I'm tired of it myself. We want answers, and we won't take no for an answer. We want the answer to be yes, and we want the information. So, have you or your department been actively looking for these documents, and how many have been gathered so far? I mean, have you actually been looking for them? Have you lost some of them? Where are they? What's going on? Because it's taken just an endless amount of time. And I'm sorry, didn't mean to interrupt you, but today we just learned that, well, we're willing to talk about it some more. We'll get together over coffee. We don't need the coffee. We don't need to get together. We want the answers.
Congressman, I hear your frustration. As I mentioned earlier, I've been a congressional staffer. I've been on the side of these investigations. I worked with Chairman Chaffetz in investigating misconduct at the Department of Defense that uncovered hundreds of millions of dollars in waste, fraud, and abuse. So I completely understand the value of your oversight, and I bring that ethos with me every day to the Department of Justice. What I'll tell you is that in talking about specifically the searches at Mar-a-Lago, President Biden and former Vice President Pence, that we are happy to work with you and your staff on those matters.
But no, tell me now. I mean, you're a smart man. Obviously, you're great credentials. You're here. Why would you need 30-some people to go into somebody's bedroom, to go through their house and use and have all kinds of arms when it's the former president, unprecedented? Yet in another case, very similar situation, definitely documents that shouldn't have been out there. There's hardly anybody, and everything is slow, relaxed, easy, and smooth. I want to know why. I want to know why there's a difference. That's all I want to know. It's a simple thing. You did one thing one way in one place. You did something else different in another place. Why? Did you really think it was that dangerous to go in there with the Secret Service being there? Did you, is that, tell me, or do you have a problem with the Secret Service?
Congressman, the Attorney General has spoken directly to this and said there are not different standards for Republicans or Democrats.
Sure was.
He has endeavored to approach each of these instances consistently. That's why we appointed special counsels in both the Trump matter as well as in the Biden matter. And we are working with Congress and congressional leadership specifically to discuss potential oversight of the documents that are at issue there. We're committed to that, but we also are committed to handling those three matters in a consistent manner.
Mr. Uriarty, in all deference, and to be as polite as I can, you know, I'm from New Jersey, so it's a little tough sometimes. But just to say to you, that means nothing to me. I just want an answer. You ask me a question, I will give you an answer, yes or no, and this is why. One place you did it this way, another place you did it radically different, why? And then the second question is another question. What was done with the request we provided the last Congress? Why was that request ignored? Nothing happened with that. And you had a lot of time. You had time to at least start on it. What happened? Yes, no, give me an answer, something, please.
Gentleman's time has expired. Gentleman can respond.
Thank you, Congressman. In response to that request, we did send letters back to the committee. Again, recognize your interest here. I will say what we have prioritized in our responses to this committee are the documents and information that were subpoenaed related to the Attorney General's October 4th memorandum. Of course, if there are additional information you want to share today about your priorities, that is helpful information, and we'll absolutely
I yield back, but I just want to say what you just said means as much to me as this does. And by the way, I want everybody to look at this and tell me what they glean from this, you know, substantive information that's up there. Thank you, Chairman.
Gentleman from Maryland for 5 minutes.
Thank you, Mr. Chairman. I think if I heard you all correctly, the chairman and the gentleman from New Jersey, I think the point you're trying to make is that when you made requests, when you were in the minority, you should have gotten productions from the government. In other words, the minority has rights to seek and compel production of documents without the assistance of the majority. I certainly hope that's the case. We're in the minority now, and I would love to have the ability to do that, so we can discuss whether that's which actually meant or not later on. But and I did want to address a couple of things too. I certainly share the view about the threats against the Supreme Court justices, the protests against them. To the extent violent threats were made, those people should be prosecuted. My recollection, without I could be corrected, but I thought one of the individuals, the one who had made threats, had been arrested as in the middle of being prosecuted now, I believe in federal court. So I think that's exactly what the Justice Department's supposed to be doing. And I would note, too, to the extent we're talking about threats to public officials, and we can make these documents available, but school board members in Loudoun County and across the country have been subjected to these kinds of threats, death threats. We've got some up behind us. I'll submit a couple more for the record. One was a school board member, actually from Florida, I believe, who wrote about it, and the school board member, she mentioned that they burned FU in her yard, that they were coming for you. We're going to make you beg for mercy. If you thought January 6th was bad, wait until you see what we have for you. I'll submit that for the record. The threats against the Georgia Secretary of State, Mr. Raffensperger, who is still getting threats, by the way, for taking the courageous stand to refuse to submit to Donald Trump's demands that he lie about the election returns in Georgia. He's getting death threats for that. And we don't have to go all the way down to Georgia either, because they're getting death threats in Loudoun County too. As a matter of fact, they sort of peaked. They jumped at the time of the January 6th event, and then they came back up in the following summer, which is, I guess, what the point of these subpoenas are about, because that was some of the time when the rhetoric ramped up. Oh, here's the chart right here. So you see the big jump coming there in November, December of 2020 into January 21. That was the raid on the Capitol. The dotted line is the total numbers. The blue line, which you can see peaks around there in October, November of 2021, that comes during the time when Republicans started making efforts to go after school boards. And the Proud Boys have got an article we can submit for the record on that. And we've got an audio tape. I don't have time to play it now, but from a group in Virginia that explains they targeted the Loudoun Public County School Board in an effort to ramp up opposition to certain policies that they disagree with. And roughly at the same time that they were ramping this up, as you can see there in the graph, the threats jumped up against these officials.
Without objection, the article from the Washington Post and the article, what was that, CNN, are entered into the record.
Thank you, Mr. Chairman. And I did want to close with this. The gentleman from New Jersey said he didn't know more now than he did before the hearing. I'll say this. The party submitted over 1,000 pages, like almost 1,500 pages of documents, and they go directly to the issues that were requested by the subpoena. And to the extent there's some kind of subtle accusation about an attempt for the Department of Justice to go after parents, I would just draw a contrast between the Attorney General's document, October 4, which goes to this issue. And basically, he said, I want you all to convene meetings, U.S. attorneys, federal officials, meet with local officials and have meetings. Ask them if they think there's a problem. If you go to the document production, you can see on DOJ HJC 155 that the head of EOUSA, in following up on that, sent instructions out telling people, quote, convene a meeting by November 3, 2021. And then if you go back further, in the documents that have already been produced to the committee, so we have these in our possession right now. So if you go to DOJ HJC 144, this is from the feedback they get. And it says, we received feedback after a meeting from the chief of Richmond PD, and the meeting was the Western District of Virginia. So it wasn't the whole state, but that's how the U.S. attorneys divvy it up in Virginia. There's the Eastern District and a Western District. So the chief of the Richmond PD says that he's assigned uniform officers to attend Richmond school board meetings, which has been well received by the school board president despite initial hesitance. With the officers present, meeting attendees were able to calm down and the board conducted its business effectively. And then with respect to the issue of weaponization, I would draw the contrast between the memo from the Attorney General, and I know I got one extra minute like my colleague had there. And I would ask you to draw the contrast between the Attorney General's memo with respect to these school boards and the one that goes out with respect to the attacks on airplane flights. I think that was one on the graph there too, where that jumped after people got upset about the mask and they started losing their minds and getting violent on planes. In that memo, the Attorney General says, I am directing United States attorneys to prioritize prosecution of federal crimes occurring on commercial aircraft that endanger the safety of passengers, flight crews, and flight attendants. Now, when the Attorney General wants them to prosecute, he said it. And the one with respect to the school board, all he says was convene meetings, and based on what we've seen in the documents that have been produced so far, that's all they've done. No attempts to go after parents, no threats, even though threats have been made against school board members, nothing of the sort. I yield back.
Thank the gentleman. I think he's done a good job of pointing out that we have different crimes, one of which is federal, one of which is primarily handled at the local level, and is better handled at the local level. But the gentleman from Texas.
Secretary Graham, I'm going to come back to you. Thank you for your time once again. I want to revisit the notion of how this process begins. Is it customary for the Department of Education to sit on requests by letter from this committee and wait until they receive a subpoena to respond with documents?
Thank you, and I actually left my light on this time. So the department has been engaged with this committee for over a year with responsive documents that culminated in our March 1st response to the subpoena, which was over 1,000+ pages, over 300 documents. And we will continue to engage in that process, working with the committee, and look forward to that opportunity.
So going forward, I hear your commitment to respond to informal requests so that we don't have to get to the point of a subpoena request. Is that your commitment?
We look forward to working together with the committee, which we have been doing for over a year now, and very glad.
That really doesn't give me a good fuzzy feeling when you respond like that. I think that was a fair request for your commitment to respond to requests by an informal manner, as you indicated earlier you would do in good faith through the process of accommodation to accommodate the requests of this committee. Would you commit to that?
And the good news, Congressman, is that we have another opportunity to do that on Tuesday, and thankful for the opportunity to work together with your team.
As part of the good faith process to, in particularly, look at the redacted documents that we see back here and others that are redacted, how do you foresee that that's going to happen moving forward to determine whether or not these redactions are appropriate and which ones should or shouldn't be redacted and which ones should be more fully disclosed?
Well, that's part of the ongoing accommodation and compromise process that we've been engaged in and look forward to continuing to be engaged in.
And forgive my ignorance. Again, I'm brand new, and then I'm new to the game of producing documents in Congress, but I would assume, in the judicial process, you're going to have an in-camera review, and somebody's going to say, yes, this should or shouldn't be redacted, or yes, this should or shouldn't be produced. So is that what's going to happen when we leave here today? You're going to allow somebody from the committee or somebody from the staff of the committee to look at what's behind the redactions and to work through whether or not that should or shouldn't be redacted?
The technical aspects of our more than 1,000 pages of substantive documents pursuant to the subpoena, certainly something that could be discussed during the accommodations process.
Well, certainly, I got to believe this is not your first time to go down a production of documents issue. How does it normally work? I'm just curious. How does it work when you say, well, we're going to work with the committee in good faith to determine whether or not these redactions are appropriate or not? How are we to determine that if we can't see what's behind the redaction?
It's part of the ongoing conversation that we are having, and
I'm trying to figure out what the conversation is going to be. Are you going to tell us what's behind there? Am I going to get to know? Is some member of the committee going to get to know? Or are you just going to say, trust us, it should be redacted?
we will continue to have those conversations about any of the issues that have been raised today by members of this committee on both sides of the aisle. That is my commitment as the Assistant Secretary for the Office of Legislation and Congressional Affairs.
I read into your answer that I'm never going to know what's behind those redactions, and neither is the American public, and that really concerns me. Again, I want to go back to the good faith accommodation issue that you guys have both talked about today. All this stuff is redacted, and it seems to be unilaterally decided on your end of the spectrum. I want to know what's behind the redactions and whether or not the American people should see that. And in fact, they should see that.
Congressman, again, the redacted components of our production are deliberative process, attorney-client privilege, and/or personal information.
Do you have any employees, let's talk about supplementation. I just have a minute. Do you have any employees specifically dedicated to the continued production of these documents?
Congressman, we have a team that is working very diligently to meet the requests that we receive from this committee, and we will continue to do so.
In the Department of Education, in your segment of the Department of Education, do you have somebody you're going to go back to and say, look, you're responsible for figuring out if there's any more to produce? Is there somebody else that we need to have here to answer questions?
That process will continue, and again, look forward to having the opportunity next week and following weeks to answer any questions you have. I'm happy to take anything back.
Okay. Thank you, Mr. Chairman.
The gentlelady from Florida is recognized for 5 minutes.
Thank you, Mr. Chairman. I'll begin by noting that I believe the gentleman from Maryland is correct, that the man who attempted to assassinate Justice Kavanaugh in his home, my understanding is, was ultimately prosecuted. However, unfortunately, that horrific incident is just part of a much broader, more pervasive, ongoing threat to our courts and to our justices that has been the subject of requests for production of documents and information by this committee. Specifically, there were several incidents in which Supreme Court justices were threatened because of their previous judicial decisions, and incidents, these fit into a larger campaign that is designed to threaten and intimidate, to frighten and dissuade justices from issuing opinions. One group published the home addresses of 6 justices and has organized harassment at their personal residences where they live with their spouses and their children. This is clearly an effort to intimidate and threaten these justices and to attempt to affect their decisions. In a letter dated June 23, 2022 to the Attorney General, this committee noted these actions appear to be attempts to intimidate and influence the justices' rulings in violation of Section 1507 of Title 18 of the U.S. Code, which prohibits pickets or parades in or near a building or residence of a judge when done with the intent to interfere, obstruct, or impede the administration of justice, or with the intent of influencing any judge in the discharge of his duty. While protesting is a protected and fundamental First Amendment activity, courts have distinguished conduct that is intended to obstruct or pervert the course of justice. That conduct does not retain such protections. This letter went on to request 2 categories of documents. The first, all documents and communications between or among the Department of Justice and the Executive Office of the President referring or relating to the harassment and intimidation campaign outside of justices' homes. Mr. Uriarte, to date, have any documents been produced in response to that January 23, 2022 letter?
Congressman, thank you for the question. I want to start by saying, as you know, this issue is something that is incredibly personal to the Attorney General as a former judge. And as you may remember, after the Dobbs decision leaked, he took the unprecedented step of having the U.S. Marshals protect the homes of the justices. We've had as many as 70 U.S. Marshals in place to protect those justices' homes, and their mission there is focused on life and safety of the judges. And that is something that is incredibly important to the AG and incredibly important to all of us at the Department of Justice. Now, in terms of the document request that you're referring to, of course, I'm happy to take that back and see if there's additional information that we can provide. Again, part of the value of these conversations, I think, is to understand the priorities of the committee. And if this is an issue that is a high priority for the committee, as I understand you're saying now, that will definitely inform our ability to produce those documents or to get you information sooner.
So would it be correct to say, Mr. Uriarte, that as of today, no documents have been produced in response to request number 1?
I don't have that request in front of me, but I'm happy to take that back.
Request number 2, all documents and communications between or among employees of the Department of Justice referring or relating to the harassment and intimidation campaign outside of justices' homes, including those sent or received by employees of the United States Attorney's Office for the District of Maryland and the United States Attorney's Office for the Eastern District of Virginia. Mr. Uriarte, same question. To this date, have any documents responsive to request number 2 been produced to this committee?
Again, I'm happy to take that back, but as I said, my commitment to you is that we will work with you and your staff to be as efficient and effective as possible and respond to your requests. And again, the more we understand about your priorities among the various oversight requests, the more effective I think we can be at helping to meet your informational need.
But to the best of your knowledge, as you sit here today before this committee, to this date, no documents responsive to this request from this committee have been provided.
That is consistent with my understanding, but I want to get back to you on that. And again, that request is from the prior Congress. Starting in this Congress, we have taken steps to respond to the committee's requests, including the production of 448 pages earlier this month on a different topic to which was the subject of the subpoena. But again, if this is a priority for you, we will certainly take that into account as we continue to work through the various requests.
And I will note that this letter concluded with a request that this information be provided as soon as possible, but no later than 5 p.m. on July 8, 2022. And with that, Mr. Chairman, I yield back.
I thank the gentlelady. That concludes our second round. I want to thank our witnesses for appearing today. I have to say I'm disappointed in many of the answers. I'm not disappointed in the commitment to continue the conversation. It's a shame that it reached this point because these conversations between staff, you spoke to great staff conversations that go on. You spoke to a knowledge of previous requests, but unfortunately, it has come to this. So hopefully, we will see additional progress being made over the next month. Otherwise, we will plan on seeing you here again very soon, probably in 3 weeks.
Mr. Chairman, would the gentleman yield for just a moment?
I'll yield.
I certainly agree that it's disappointing that it got to this stage. We may feel disappointed for different reasons, but I share your disappointment.
Thank the gentleman. All right. Without objection, all members will have 5 legislative days to submit additional written questions for the witnesses or additional materials for the record. Without objection, the hearing is adjourned.